Viewers, welcome to the Personal Injury Law Show. This show talks about everything current law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. We've been told I've got a partner in a law firm in transport accidents, Don Maffia. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And a lawyer from Slater and Gordon in transport accidents, Anna Jennings-Edquist. Good evening, Anna.
Good evening, Tony. Good evening, viewers.
Viewers, tonight, stay tuned. We're going to give you a transport accident update. We're going to give you some cases and also what's happening in the world of transport accidents.
Well, yes, Tony, and we're going to applaud the government, the Victorian government, who held their election promise to make some changes to the laws, which is great for the plaintiffs. But before we get into that, Tony, let's talk about what's in the news.
The Holden Capri, Anna, it's causing a lot of issues with the steering.
Yes, this is a bit of a bizarre story that it hasn't really been taken care of so far. What a lot of complaints are being made, particularly by taxi drivers who are driving a lot of these cars, is that the power steering is suddenly locking up. So you've got cases of people who are driving down the freeway, driving along the Balti Bridge, and suddenly the steering's just completely frozen up and they're having to sort of lean on the wheel to get it over to the emergency lane. It's really an accident waiting to happen.
Exactly. And Don, what about this thing where Holden have actually said to a particular person who owns a Capri, if it sees up on you, stop the car and start again, and it releases it.
That's ludicrous.
Is that a joke or what?
It is a joke, Tony. And we're seeing a lot of this happening too. I mean, not long ago, Tony, there was that Volkswagen where a lady the cable got stuck in the accelerator and ran to the back of the truck and unfortunately she died. So this is like I said, disaster waiting to happen. And Holden have to do something about it. I mean, or else it'll be too late, Tony. There'll be a death and then they're going to recall the vehicle?
Exactly.
Should be the other way around.
Well, I guess the
death.
problem is you're dealing with large corporations, and if something happens, no one personally gets prosecuted. Yeah. The company gets prosecuted, the fine's minuscule when you consider the size of these organisations. Yeah. So maybe if someone was held to account, it could be different.
Oh, well, look, Tony, look at what's happening with Audi at the moment. I mean, with the emissions. They still haven't sorted out a solution to it. Now, I know there's no danger to the vehicle, but if there was a danger, this is a situation where it's a disaster waiting to happen, and these people, Holdens or your likes, they should get onto it straight away.
Well, Don, it comes down to dollars and cents. I mean, they look at the bottom line, sadly. And tell us about these baby death count at Bacchus Marsh Hospital, where it's up to 12 now.
Yeah, this is shocking. So there's been a review from Professor Ewan Wallace recently into these deaths, and they found that between 2013 and 2012 there were 7 preventable stillbirths and infant deaths, and that follows a review earlier which found that there were another 5 preventable deaths between 2001 and 2013. So that takes the total up to 12 preventable deaths. And in fact, since this has all come out, there's now been 43 complaints to the Health Services Commissioner about these incidents, and 15 of those are in 2013 alone.
Don,
why did it take so long to highlight the problems at this hospital?
Oh, look, it sounds like, the amount of deaths there, and I think when it says preventable, I think there are situations where they could be referred off earlier to, let's say, the Royal Children's Hospital.
Obviously, the hospital lacked the necessary specialisation or expertise to deal with these cases.
And we don't know what explanation they were given by the hospital as well, Tony. So, look, we don't know. I mean, obviously there's a lot more to come out of this. I mean, it's been investigated. There's lots of complaints there, so I'm sure it's not the last time we hear about it.
Well, the doctor that was running the place, he's saying that they've done nothing wrong.
Well, look, they're investigating it to make sure that, to find out what has actually gone wrong to make sure it's never happening again. I think to suggest that there's been nothing done wrong when there's been that many incidents seems unlikely. I mean, there has been statements by the Health Minister saying that they're doing a lot of things to try to rectify it. They're going to pour some funding into it. They're bringing in experts from Western Health and Royal Women's Hospital to try to lead some training. So hopefully these things get solved. But it's tragic to think that you've got people who're making complaints now from 1990 even, who've been without answers for all of this time. Could be the tip of the iceberg,
who knows?
That's right, yeah.
Viewers, if you've been affected by this business out at the Bacchus Marsh Hospital, don't hesitate to ring one of us 3, and obviously there's a lot of other people out there that can help. So keep in mind, if you're not sure, give us a ring and we'll give you some advice. Don, I find this absolutely outrageous. 1 in 5 tradies are testing positive to drugs, such as ice, cocaine, on building sites. I mean, can't go on, surely.
No. And look, Tony, we think as a drug culture affects us socially, but obviously now it affects your vocational workplace as well. I mean, the situation is strife at the moment, and we need to do a lot more, and particularly these people on construction sites, Tony. We know they're dealing with heavy machinery.
Yep.
It can cause a lot of injuries and a lot of harm. So glad that they're doing it. Obviously, it is expensive exercise, but I think it's a worthwhile exercise.
Yeah,
Anna,
right.
the safety of your fellow workers is paramount, correct?
Absolutely.
If you're not prepared to look after your own well-being, at least consider others.
Yeah, that's exactly
I mean,
right.
society's become too indifferent. It's absolutely a joke, isn't it? Anyway, the number of road deaths, and you two are both transport accident lawyers, there's been 26 motorcyclists killed so far this year, when the total number last year was 29 done. It is, what's going on?
Outrageous. I think that the article was based around having more of this rider-aware ads campaign by the TAC in Victoria. Historically, TAC used to have a lot of good ads, and we just see about the motorcycle. Remember,
Yeah, I
look
agree with
left,
that,
look
Don.
right,
I do remember those.
And
Yep,
it just seemed to put that in the back burner and just more do with the more generalistic towards zero road deaths ad campaigns. I think it's got to be more specific, and obviously there is a lot of push by the different bodies to get more rider specific ads.
Yep. And if this is the numbers that are dying, who knows how many are actually seriously injured?
Well, that's right. That's the thing that gets masked when you see these death tolls.
Yes.
It actually doesn't tell us anything about people who've had their lives completely ruined by a
Yes.
motorbike accident.
And most motorcyclists that come off, they don't come off with minor injuries, do they? Yeah. Viewers, we've got to get our sponsors break. Stay tuned. After a break, we'll give you a TAC update. Viewers, welcome back to the show. We're going to give you an update on legislation and also cases. But firstly, we're going to talk about the changes to the laws in relation to psychological injuries / psychiatric. In October 2013, the government did away with psychiatric injuries in the sense that to be able to claim damages, the test was so high that effectively it cut out most claims. Is that correct, Doug?
Correct. It was just a harsh test. And we've done a number of shows on this too,
Yes,
Tony.
yes.
We've spoken about it a lot. It was just nearly impossible for people who sustain psychiatric injuries to make a claim
To
for damages.
mount a claim and be
just
successful.
it's just
Yep,
for the
yep.
viewers. In Victoria, to make a claim for damages, you must show that you've got a serious injury. And the government defines a serious injuries for psychiatric purposes to mean a severe psychiatric impairment. The change in October 2013 made that test nearly impossible. It brought in a 3-year test, Tony. You had to show that you had 3 years of continuous treatment, that's failed the treatment, and affected your vocational and social and relationship. So
Okay.
it made it impossible.
Anna, one of the problems with the system with its change was that people that didn't want to get treatment on a regular basis were forced to get treatment to satisfy the test, where in circumstances where there wasn't much they could do. So they're probably forced to go on the medication and get counselling in circumstances where it wasn't going to help.
Well, absolutely. And it also creates a very difficult situation for people who are living remotely and it takes them sort of 2 hours to get
Yes.
into town to get treatment. And then if they've had an accident, it's going to be very traumatic for them to travel 2 hours, whether it's by car or tram. So it's sort of probably worsening their injuries anyway, even though they know it's having no effect on their, recovery because they're trying to satisfy this legislation. And then you're also essentially punishing stoic individuals who have tried to maintain going to work, maintain their relationships and so on, and then they're being punished because they're then not meeting that test that says you need to have been severely affected at work, in your relationships and so on.
And viewers, on the back of some serious lobbying by none other than myself and these two lovely people, we've managed to get the government to scale back the test. And now where are we at, Don?
Well, the test has gone back to status quo, to what it used to be before the changes in October 2013. So the test is you just have to show the severe consequences. So it makes it still a high test. It's always been a high test, but it moves away this harsh and unjust rules to say, well, if you haven't had treatment, which a lot of people who suffer from psychological psychiatric impairment don't have treatment for whatever reason. Doesn't necessarily mean if you're not having treatment that you're not being affected. Some people, like Anna said, do go back to work, but still psychiatrically affected.
Yep.
So it's removed a lot of the harshness. It's still a high test, But congratulations to the government. They did say in October 2013, the Labor government said they'll make those changes, and after lobbying, and they've made those changes.
And fortunately, Anna, it's restored the rights of third parties or bystanders that witnessed accidents, serious accidents, nervous shock claims.
Well, the test, Tony, there was a different part to the changes, and it hasn't been well documented in any, even our shows. We haven't spent much time on it, but it was a situation where if you have a nervous shock or mental injury and you weren't directly involved in the accident or did not witness the accident, so you may have witnessed the aftermath, but this falls people, you didn't witness it, and the transport accident was caused, and I'm just reading, by suicide or intent to commit suicide, or predominantly by the negligence of the person or death of the injury. So this is someone, if you have, like, for example, CFA or first attendant at the scene after the accident.
So the emergency workers.
Negligence of a driver, no other vehicle involved, and there's a death or serious injury, then they had no claim. So that's been removed. There is still some issues as to whether or not the common law allows these type of claims to take place, particularly where it's self-inflicted injuries. That's still to be tested before the courts. But it does remove away a lot of the claims that could have been.
Well, Don, on the back of what you've just said now, it just highlights to viewers how important it is to ring Anna, Don, or myself, or anyone else for that matter in the organisations, the Slaters or the Wiki Carbone, to get an opinion or an advice very early in the piece to make sure that you're on track. Because you've just heard how complicated the whole system is. It's very convoluted, isn't it?
Correct.
Yep.
Sure is.
All right. On that note, if you've got any other questions, don't hesitate to ring. We'll keep moving. Let's get on to the cases. The first case, viewers, is Philippides and Transport Accident Commission. It's a Victorian County Court decision. Anna, it was recent. Can you tell us the facts?
Yeah, so this was an 83-year-old applicant who'd immigrated from Greece. He was actually somebody who had quite a few injuries going on. So back in, I believe it was 1963, he'd actually had a fusion of some neck vertebrae. Shortly after that, he'd developed some sharp neck pain, so he'd gone back to the doctor and had another scan done which had shown some degenerative changes both above and below the fusion. He's then been involved in a motor vehicle accident in 2008, which he said has aggravated those injuries a little bit, and then another accident in 2011. And at that stage, he's been referred off for further treatment, including, I believe it was nerve root injections and so on. He is now bringing an application to the court
for serious injury.
For a serious injury.
Don, this case turned essentially on the clinical notes of the treating GP.
Correct.
Tell us a bit more about that.
Well, look, Mr. Philippides made an application saying that before the accident, he essentially, just not verbatim, but he's saying that he was fine. He participate in an unrestricted sort of domestic and social recreational activities. He wasn't working, but the clinical notes of the doctor was somewhat inconsistent with what he was trying to say.
Well, the notes basically said that his conditions or his pain and other sufferings post those two accidents hadn't changed.
Correct, but the GP provided a medical report saying that the accident really hasn't changed his neck condition. So not only the clinical records were somewhat inconsistent with what Mr. Philippides was saying, but furthermore, the doctor went further and said, I don't think there's any aggravation of that neck injury from the accident.
It seems a bit odd, doesn't it, Anna, that he's been hit in these two accidents and his treating doctor, I'm not sure if he's even explained to him that he doesn't think he's suffered aggravations. Do you think he knew? Probably not.
Well, I mean, I think that there has been some aggravation, and if you look at the progress of this man's injuries, he's ended up with foot drop from canal stenosis. So he's clearly got some very serious injuries going on, and the question is really, can you attribute it to either of these accidents or none of the accidents, and it was actually related to degenerative changes and so on. So you can see why the lawyers have brought the application. You can see why the client feels that there's an aggravation there, because there's clearly been a change to his health. But the question really falls down to what the law says, that you must attribute it to one of the accidents.
Don, this particular plaintiff saw a lot of doctors, correct?
Yeah.
There was some that took the view of the GP that, not much has changed. And there was some that said there were significant changes.
Yep.
However, you and I and Anna know that in the court system, the courts place significant and a lot of weight on your treating GP and also treating specialists. So in this situation where you've got the treating GP that's turned, well, really hasn't supported the plaintiff, you're up against it trying to win your case.
Yeah, in this case too, Tony, the whole appeal turned on two facts. One there wasn't proper path of reasoning.
Yeah.
That wasn't allowed. But the other one was more so where you have these clinical records, and when the plaintiff, Mr. Billis, put his case, when he was given his evidence, the defendant, or the TSC in this case, never put those notes to him and raise any prior inconsistencies.
All right.
That was the whole basis of the appeal base.
I'm going to put the viewers on suspense.
Yep.
And we'll get back to it just after the sponsors break. So stay tuned, viewers. Viewers, welcome back to the show. Don was just going through the path of reasoning for the court to find what?
Right. So at the end, the appeal was dismissed. But the point was, Tony, was that the notes or the inconsistencies were never put to the plaintiff during his evidence.
Yep.
So procedural fairness says if you're going to rely on it, you've got to put it to the plaintiff, give an opportunity to explain. And that never was done.
Yep.
But the defence counsel, when they ran the case, they didn't rely on the inconsistency. They just said all your comorbidities are affecting you now, not this neck injury.
Are not to do with the accident.
But the plaintiff's own lawyers relied on that evidence. And that's how the judge could put so much weight on those clinical evidence and in the medical reports. At the end of the day, the Court of Appeal said, look, it was right, it was open to the judge to conclude what she did. And at the end, the appeal was dismissed.
Anna, more often than not, if a defendant fails to cross-examine, your evidence goes in unchallenged. As Don rightly says, because the notes didn't assist, that was the end of the ballgame.
Well, that's right. It's very difficult. If you've got a general practitioner who you've been seeing all the time who's taking contemporaneous notes of what you're complaining about, it's very difficult to come back many years later and say, oh yes, but I was actually experiencing all these other symptoms that just haven't been recorded. And the judge noted that even though they weren't in the clinical notes, maybe there might have been other things that were discussed. However, that wasn't reflected in any of the reports either. In the reports, it was still saying as late as 2010, when the accident had happened in 2008, that really there'd been no aggravation.
Don, the moral to the story, if your doctors don't support you, don't waste your time.
And also, Tato, I think what people don't realise is when you go see a doctor, you don't take notes as to your outcome or what you discuss with the doctor. The doctor does.
Well,
so it's all there. The history will be there.
Getting this doctor to say to him, look, I don't see any of your current symptoms to be related to these transport accidents. I mean, he's almost led him on, hasn't he?
Well, but then again, Tony, you're not seeing a doctor for the purposes of a legal case. So
well, he knew there was a legal case.
Well, later on he did, but look, like I said, the notes are quite important in these cases. And definitely you should be acquainted with what you've told. You should remember what you've said to your doctor.
Well, Don, he's led him on. The poor bloke's 84 years old, hasn't got many more years, quality years ahead of him. So he's probably taken 5 or 6 years to get to court. He's lost his case, totally disillusioned. I think the doctor should have come out and said, look, I don't support your case. Right. And that's another thing you've got to watch out for, viewers. Make sure you've got a doctor that's compassionate and sympathetic. All right, let's keep moving. Secretary and Department of Social Securities versus Sneddon. It's an AAT decision, Anna. Can you give us a bit of the facts of this?
Yes, so this was a young man who'd been injured in a motor vehicle accident and he'd received a lump sum of compensation for an impairment benefit and then a lump sum of compensation by way of a common law claim. And that common law compensation was for both his pain and suffering and loss of enjoyment of life, but also for his economic loss. And when you do resolve a common law claim for economic loss, you can be precluded from claiming Centrelink because you might end up essentially double dipping.
Yes. Well, viewers, generally you are precluded from claiming Centrelink benefits for a period of time. And Don, what happened in this?
Well, this took it on. So just for the viewers, Tony, if it's a settlement out of court without a jury verdict, then it doesn't matter how you settle your case. You could settle your case for $200,000 for pain and suffering and $10 for economic loss. What Centrelink does, it just takes half to mean pecuniary or economic loss.
Half the pain and suffering and half the
of
loss
that.
of
So
income.
regardless of
Yep.
how you settle it. So I said $10 for pain for economic loss and $200. It doesn't matter. So they take half and then they apply a formula, which is sort of like the average weekly earnings sort of thing,
Yep.
and then work out the number of weeks that you'll be precluded.
Yes.
And then if you've received any, and the preclusion can start from date of accident or last date you received payment. If you received any payment for Centrelink during the preclusion, you've got to pay back.
Yes.
So Mr. Snedden settled his claim. They applied that formula and worked out the preclusion plus the payback. He wasn't happy with it, so he went to court and sought like a special circumstance or used discretion by Centrelink to waive that preclusion and that
Well,
payback.
first and foremost, Don, there was a preclusion, correct?
There was preclusion
And then he
because
wanted to
received
apply a
payments.
special circumstance.
Correct, so there was
Yep.
payback as well.
And what was the special circumstance?
Well, he said his legal advice, and
Okay.
he said he was given wrong legal advice. Now, the tribunal didn't go into much detail. We couldn't know what that legal advice was, but the judge said, look, doesn't matter, or at least the member said, look, doesn't matter. In the end, it's correct what's happened.
Anna, that raises another issue. He's been affected financially in the sense that he wasn't told about the preclusion period, so he's lost X amount of dollars. If he can quantify that loss, and if he wasn't going to lose that money anyway, he's got a claim against his lawyers for failing to advise, correct?
Yes, that's probably right.
Right, talk about that. But look, Tony, I mean, the thing is, Centrelink, I mean, if you're not sure about Centrelink, you can ring up Centrelink directly. You know, they have a setter team in Victoria, across Australia, who deal with compensation.
This
And
case
as quick as pick up the
highlights-
phone.
This case highlights, Don and Anna, the significance of getting quality legal advice, correct?
Correct.
Because if you've got the wrong advice, you've got issues.
Well, what people don't realise is that the Centrelink laws are paramount. So this goes back to Constitution days, where there's two acts, a Victorian Act and a Commonwealth Act. The Commonwealth Act prevails.
Yes.
So it's federal. So in this case, it doesn't matter what the Victorian laws says about it. Centrelink trumps Victoria.
Now,
So
Don's
that-
given us
yeah.
our constitutional lesson for today, but the thing that's important is, viewers, these cases are very complicated. You need specialised advice. Ring up Banner at Slater and Gordon or Don Maffia, who runs a TAC department at the Wiki Carbone. Get advice and get it from people that know what they're doing, for the simple fact that if you don't do it properly, you're going to have nothing but heartache and other issues.
Yeah, you can call us on 1300 Injured or go to our website.
Viewers, our last case, and we've got to be brief because time flies as usual, the TAC and Transport Accident Commission. Anna, do you want to give us the facts briefly on this?
Yeah, so this was a man who'd been injured in a motor vehicle accident in 2007, in May 2007. In 2011, he's undergone a scan which has shown a torn rotator cuff. There's been one doctor who's recommended that he undergo surgery to repair that rotator cuff, and he's applied to the TAC to fund that treatment. And the TAC have said no on two grounds. One, they've said that the rotator cuff injury is not related to the motor vehicle accident because there's been such a big time delay in actually diagnosing the injury. And secondly, they've said that even if they were liable, they wouldn't pay for it because it's not considered to be a reasonable cost of treatment given his age and his ill health, that they wouldn't recommend, or doctors wouldn't recommend the treatment anyway.
And Don, what was the result?
Well, he didn't win his case, unfortunately. But look, Tony, this is a case where there is a 4-year delay in identifying the injury, which is a tear. Although there may be
I still
some
think
complaints.
he's pretty unlucky because you're at the mercy of whoever examined you and treated you at the start. Because if you're complaining of symptoms and they haven't carried out the proper investigations, like maybe ultrasounds and MRIs, you are at a
but
disadvantage.
a tear, yeah, look, a tear like that could show up straight away. But
On
look,
what?
we're not doctors on scanning or
ultrasound?
whatever.
But it
they
is
do
interesting that you say that because, in fact, he did undergo some tears that didn't show that there was... he did undergo some scans that showed that there wasn't a tear, or it didn't identify a tear when it would be likely to have done. So he did undergo those investigations.
So a bit more.
Suspicion
The doctors would say it's a bit more got to be consistent with time. But
Well,
the
the
other
suspicion
point
is
which
he
Anna-
sustained the tear
Anna, mate,
after the accident.
the suggestion that he had this chronic pain syndrome, which arguably the doctors say it's psychological.
Yeah.
So they said even if it was related, the surgery wouldn't help the overall condition.
Well,
so
Don, the
therefore it
moral of the
wasn't
story
reasonable.
is if you had a representative or Anna, we probably would have won the case. But anyway, the poor plaintiff lost. like I said, get proper representation. Anna, thanks for coming on board. We're at the end of a show. Don,
Thank you
always
for
a
having me.
pleasure.
Thanks, viewers.
Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes on YouTube. Go to our social media platforms, and always remember to stay safe.